Our firm has been primarily a business litigation firm over the years. Unfortunately, litigation or lawsuit is a reality of operating almost any business in today's environment. We have represented small businesses, family businesses, and even Fortune 500 companies. As part of the practice of litigation, we deal with these business disputes in an effort to try and get them resolved. Litigation involves arbitration proceedings, federal court proceedings, state court proceedings, any number of different tribunals in which a dispute can be resolved. What we've discovered from our litigation practice over the years is that by experiencing disputes and seeing how they come out in the court systems, we have learned how to advise our clients up front as well. So we've also engaged in the transactional side of the practice involving drafting of contracts for clients in an effort to allocate risks and responsibilities on various different projects. The type of litigation we provide involves real estate disputes, construction project disputes, any number of business disputes from breach of contract to disputes between business partners to corporate director or officer liability, securities fraud cases, infringement, unfair competition cases. Those are the areas that we have worked over the years.
Our website will tell you that we offer services in construction, real estate, and business law. They all have a connection. There's really two types of law that you study in law school that are involved in these areas. One is contracts and the other is real estate. And being well versed in those two areas, we find is critical in order to be able to give full service to our clients. A construction project mid-size can have as many as 3,000 contracts written during its performance. And understanding the relationships between those contracts is what takes a lawyer from the realm of just contract law to being a construction lawyer. We demonstrate that expertise through our board certifications. That is a primary area that is tested. But it's interesting then that the board certification test also includes a number of questions that are really straight real estate law. You have to understand how a construction lien works at the end of the day, what our recording statutes in Florida may mean. And if you don't have those understandings, it's hard to give a client advice when they first come in on what the end game will be. It's also a good idea to be able to know the business side of what a contractor does in order to understand the relationships that are going to be put at test during a litigation. Those relationships may become more important than the outcome. It's important to understand for a final end game what types of real estate may be involved in the project and what the chain of title may be, what the priority of the lien may be. All of these items, the more the lawyer understands them, the better advice the lawyer can give a client at the beginning session.
Obviously, our goal in litigation is to pursue the best result we can for our client. But how we reach that best outcome can vary a lot depending upon what the particular challenges are in the case. In some instances, the best result is achieved through a settlement during the litigation. Could be a settlement through what's called the mediation process. In other instances, the only way to pursue the best possible outcome is to proceed all the way to a trial, whether it be a jury trial or a trial in front of a judge. And so when trial becomes necessary, we have experience with litigating complex disputes in trial in both federal court and in state courts.
We're not a firm that does everything for everyone. We focus on business disputes. It's the business world that we're involved with. So you won't see us handling personal injury cases and family law cases and things of that nature. We're here to represent the business community and to assist our clients in becoming as successful while avoiding as much as possible the unfortunate necessity of litigation in our world.